March 6th. Not at 10:30.
I can also call Mr. Angel, not Mr. Liz, on page 7.
Actually, the week of the second week of March, I believe the judges are at Judicial College. I don't know for sure, but for now, let's not do March 13th, but you have March 6th. So if there's any change, I'm sure you'll get a memo. Next case.
Call Mr. Angel, not Mr. Liz, on page 7 of your Honor's docket.
Yes.
Judge, so I just asked him on his new law. He's currently being put on this case as well as the new law. The state is not willing to discuss in terms of release today. I would ask if your honor would be willing to put him on the side of the file. Or he doesn't have any history of violent crimes. He's not getting thefts right now.
Do you have a copy of, did you file a motion to
I was
send?
just going to.
Okay, do you have a copy of his score sheet, probable cause affidavit, anything that the court can enlighten itself?
I can provide those to your honor if the state can give a moment to review it. I just would be your honor on the page here and please walk me this morning without a motion for me to review it, but I will provide your honor because we are keeping a probable cause affidavit.
Okay, so we'll put it on recall. Next.
Good morning, Your Honor.
Good morning.
I have on page 27 of your docket, Amy Garman. Judge, we're set for set new dates. I know that Ms. Garman actually reached out to my office last week while I was out of town. And I believe she lives out of state. I did send her a waiver of appearance form, but haven't received a permanent signature back. But if I can waive appearance for the purpose of today's hearing, Judge, I would ask for a February 6th calendar call.
Your honor, actually, this case is going to be transferred before we said that we gave you the older case in Division FD. So your honor, I'm going to present the clerk with a transfer order. And I believe there's a date for the newer case February 3rd at 9 a.m.
So there's already a date?
Yeah, well, there's a date for the older case in that division. I was just asking last Thursday.
So we're gonna transfer, and then this case is gonna be set for that date?
Yes, your honor.
In front of that other information.
Correct.
Okay, sounds good.
Thank you kindly, Your Honor. Thank
So
you.
we're setting it for what for that day?
I think it's up for a calendar call. Calendar call with February 13th.
It's up to your honor.
I guess, I mean, it's going to a different division, so
Right,
I don't know what they have it set for.
And Your Honor, I can look into who is the RCC person in that courtroom, and I'll coordinate with them to make sure that.
Okay. Thank you.
Thank you, Judge. I think that's all I have for you today.
If you can, your honor, just give the state just a moment to provide my clerk with the transfer.
Sure.
Thank you. Okay. Thank you.
Let me just advise the Public Defender's Office that case Jordan Rice has sent a message to the court advising that they live out of the state. They cannot be here in person. she's not allowed to travel.
Thank you, Your Honor.
So, the Zoom link was provided to them.
Thank you, Your Honor. Thank you, Your Honor, for giving us the information.
Your Honor, the court is ready. I would like to call Brian Brown on page 11 of your docket. Mr. Brown, Your Honor.
What page did you say? 11?
Page 11, Your Honor. Mr. Brown completed an application for the public defender today. It appears as if there is a change of charge date is outstanding, and we are asking to reset it for tomorrow.
State any objection?
I just want to know the purpose of the reason.
It's, change of charge.
I understand the change of trustee, so
Yeah.
Okay. Just for record, I know that, I know we're all aware, but for the updated, no, Your Honor, no objection to reset.
So we're resetting it for tomorrow.
Come back tomorrow morning.
Anybody else? Good morning.
Good morning, Brown. Happy to meet you, sir.
Happy New Year.
Morning, Judge. I was here for a while for this case.
Judge, Mike's up.
Yeah, I was there too. I remember you. Move us around. Here, good luck. Look, this is somebody else's card. I just crossed off their name, put my name there. Yeah, those first six are the same. The last four is 86. That's how you get a bunch of results. Leave a voicemail from office. Hey, David, to remain on bond. You want me to write it down?
The new statute that Veterans Court with this area, the new statute, the state proposed to objection. One of the narratives said, unfortunately, we accept the case. So we're actually, I'm going to ask for this to be reset for the last 30 days. I've spoken this morning with Mr. Gonzalez. We never really got to the substance of some of the issues. I think it's some time that we have opportunities to perhaps schedule a state where that's a decision. So I was asking for a reset.
State any objection?
No objections to the reset, Judge.
What are we resetting it for? For status, calendar status?
So, I mean, today I know it's for set new dates. Obviously, we didn't have a date present. I'm fine with setting it for a status if you want, or a calendar, whatever the vote is.
Do you want a status?
Yes.
So, we said 30 days. We can, 30 days from today brings us to February 3rd. This division's being taken over by Judge Villalonga starting the 22nd. So I'll set it for that day.
22nd of January?
Yes.
No,
No, the division's being taken over January 22nd. The date that I'm setting it for is February 3rd. So that's going to be before a different judge in a different courtroom.
we actually had her to the judge. I apologize.
Okay, what day would you prefer?
I can do any other date. I think I can out of the office on that Monday.
Okay, you can Tuesday, can we do Tuesday the 4th?
Tuesday, 4th is fine.
So February the 4th at 9 o'clock.
Thank you.
Thanks,
Nice
Judge.
to see you.
Have a great day.
On this one.
Morning, Judge.
Good morning.
I have posted the winners of page 13 in your calendar.
Happy New Year.
Oh, my God, I had to bring on the.
What page?
13.
Yes.
We're good for change, please. Before we get started, Mr. Ramirez, of course, you have the surrender. So my question is regarding the surrender committee on the surrender date in 2 weeks, so we can get some help.
State. Judge, I have no problem with that. We discussed that, he was going to 5 years, the ultimate sentence is 3 years for state prison followed by 10 years probation.
Well, first of all, if he's sick with the flu, we should not even be here. So I don't even know why we're not resetting everything. We're here spreading germs.
I just didn't want not to show Judge we were here for the same thing, so.
Okay. So reset it for 2 weeks. Any specific date? Huh?
Are you gonna be here in 2 weeks?
I'm gonna be here, the 21st is my last day, so reset it for that day you want. That's Tuesday.
Judge, I have a, Judge, can we do it on the 20th, the 21st, have to be a federal court?
The 20th is a holiday.
I can see if I can have someone stand in. I have a federal matter that morning. If it's okay with my client, I can have someone else stand in for me. We have to take that work prepared and I'll leave it with the state.
Okay, so we'll reset it for January 21st at 9 o'clock.
Okay, Judge.
Thank you.
Thank you. David Self.
And by the way, Judge Villamont is not coming to this courtroom. She's just taking the division. I'm not leaving courtrooms.
Judge, it's okay. I don't want someone standing physically versus I'll be on Zoom that day.
That's
Just so I
fine.
can be present. Okay, sure. Thank you.
So let me get this straight, you're still gonna be doing criminal?
Yes,
Oh, all right, so that's cool.
I'll be taking
Just a
the
different division.
FP division.
Mr. Rodrigo, body, D, Arijo.
What page?
Very good.
What page?
I don't know.
Wait till he leaves you.
29.
I got it right here, 29.
Oh.
You walk in here back.
Okay, we're here for a,
A motion for early termination of his probation.
do we
I
have,
think the motion is clear, but I don't
I
know.
don't
if it's
see,
for- Yeah, because I don't think it was written for early termination. I know within the body of the motion, there's a request for that.
Go ahead and hit that like button for us. You know, it helps us out and it helps you because it helps us keep bringing you this content every day. Now, y'all, tomorrow, this is going to be Monday, the 6th of January, 2025. Tomorrow is going to be a huge day in the YNW Melly trial. As you know, Melly's going to trial again this year, 2025, after his double murder trial ended in a mistrial in 2023. Now, as you can see from Kathy Rasan, there is going to be a 2-day motions hearings for the double murder trial beginning at 9 a.m. tomorrow. So Law and Crime, they're going to be covering it and they're going to be tweeting out the link tomorrow morning. There's a new judge in the trial and a new lead prosecutor on the case. There are several outstanding motions, which we are going to briefly review here. And the upcoming trial is going to be set for September 10th. of this year. Now, as we said, in July 2023, the jury could not come to a unanimous verdict. And so Melly has been sitting in jail this whole time since July 2023 and even before. Melly is charged with double murder in the 2018 deaths of his friends Anthony Williams, otherwise known as YNW Sack Chaser, and Christopher Thomas Jr., otherwise known as YNW Juvie. Now let's take a look at some of the motions that will be up for consideration tomorrow. Now, as you can see, there will be approximately 10 motions on the table for consideration tomorrow. You have a motion to compel discovery and deposition of Christine Bradley. You have a motion to exclude conversations between CH and JM. You have the defendant's third motion to compel forensic images of cell phones belonging to Christopher Thomas and Anthony Williams. Those are the victims. You have a motion to compel discovery. You have a motion to compel depositions. You have a motion to exclude video of 1099 Jake. Now, let's get more into this motion, y'all. I went a little bit deeper into this motion. Let's take a look in particular at what this motion says and what is the background, what is the content that this motion is talking about. So I looked into it, and it looks like this motion refers to an interview that 1090 Jake, he's a popular hip hop gang podcaster. He talks about hip hop, he talks about gangs, he talks about who's snitching, who isn't. If you're not familiar with him, just search 1090 Jake on YouTube. Looks like this motion is referring to a time that 1090 Jake was on the No Jumper podcast, and then another time that 1090 Jake was on the DJ Vlad podcast. And the motion says, the defendant, Jamel Damons, by and through the undersigned counsel, moves this honorable court for an order to prohibit the state of Florida from discussing, referring to, or otherwise placing before the jury certain YouTube videos of 1090 Jake, and in support thereof states the following. 1. The state of Florida, in the supplemental discovery filing dated January 8, 2024, provided 2 separate links to video discovery titled 1090 Jake on the Island Boys claiming to be Bloods and 1090 Jake on being a white blood. 2. The YouTube videos contain irrelevant, immaterial, and inadmissible statements depicting violence and illegal gang activity. 3. The video is irrelevant to the allegations charged in the indictment. Even if the state of Florida successfully argues some of the relevance of the video, quote, the probative value would be substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, end quote. The motion continues. Number 4, the video has no probative value as to the allegations against Jamel Damons and is heavily prejudicial. So it's referring to lyrics presented a substantial danger of unfair prejudice because they contain violence, profanity, sex, promiscuity, and misogyny, and could reasonably be understood as promoting a violent and unlawful lifestyle. At the same time, the video was not clearly probative of defendant's guilt. And the motion ends. Wherefore, the defendant, Jamel Damons, moves this court for an order prohibiting the state of Florida from discussing, referring to, or otherwise placing before the jury the YouTube videos titled 1090 Jake on the Island Boys claiming to be Bloods and 1090 Jake on being a white blood. Now, I did watch the first one, the one about the Island Boys claiming to be Bloods, and it is difficult to see how that has anything to do with the YNW Melly trial. There is no mention of Melly. There's no mention of anything that I could see that might be related. So we'll be watching out to see if the judge will allow this video and the other one into the trial and see under what legal theory that may be done. But I couldn't see any connection. Now let's go back and round out the additional motions that will be argued over the coming couple of days. You have motion number 7, objection to business record certification. Motion 8, the motion to exclude James Howard Detention Communications. Number 9, motion to exclude TikTok video of Neek Baby. Now I looked for this. I looked for the motion and I couldn't find the actual motion in the list in the lineup. So I really wanted to show y'all this one, but I couldn't find the motion. And I didn't want to show you the wrong person or the wrong video. If anybody finds this, let me know. But I guess we'll be seeing it either tomorrow or Tuesday. And then finally, number 10 motion for James hearing. So these are the motions that we expect to be argued in the coming days. Maybe there will be more, but we will be covering this. Again, YNW Melly, 2 motions days coming up to help determine what's going to happen with the future of this trial. New judge, new prosecutor. I'd like to hear y'all. What do y'all think is going to happen? Do you think that Melly, do you think that Melly can even get a fair trial at this point? Melly's been held in jail for years and years. He's filed all kinds of motions to try to get out about unfair treatment, and it doesn't seem like any of that's gone anywhere for him at this point. He has had his full trial, mistrial, no verdict. So what do y'all think? Let me know in the comments. Do you think that Melly even has a chance? Let me know your opinion. Don't forget to like and subscribe. Appreciate y'all watching this, and we'll see you in the next one.
This council, this is State Drains, ladies and gentlemen, start with the case open argument. Ready, council, you may proceed with it.
So here's what we start with. Detective Moretti has an investigation that starts on October 26th of 2018. We have 2 dead bodies that are dropped off at Memorial Miramar. Christopher Thomas and Anthony Williams. We have Cortland Henry, who's lying about anything and everything. He's lying about the location of where it happened. He's lying about when it happened. He's lying about Mr. Demmons, the defendant, being in the car at any point that evening. Totally omits that. We then have the cover-up that begins. So the question is why? Why does there need to be cover-up? Because there was a murder that was committed, ladies and gentlemen, that's why. There were 2 murders that were committed. And so from here, we're going to talk about and explain what we have, right? So Detective Moretti and the Miramar Police Department have to answer 4 questions. Who, what, when, and where? And so for the where, I want to start with where did the lethal shots come from? And let's start and focus on that part of the investigation. So the where, we looked at Chris Williams. If you remember, Sergeant Williams came in and testified and showed you how Blue Star works, showed you how shooting reconstructions are done with the trajectory rods. This explained how Miramar had made a good attempt, but they lacked training. So he came in and went through and is able to explain, as an expert in shooting reconstruction, what happened in this car. So we're going to start on the trajectory rods. If you recall, on the outside, the most important aspect of the ones on the outside of the car is they show that this was not a drive-by. That they're coming in at 90 degrees, that there's no keyholing. If you remember, you learned about keyholing, that would be an angle of entry on that. So he then showed you the Blue Star. And if you recall, ladies and gentlemen, this chemical reacts no matter how many years later, no matter what attempt at cleanup is done. The chemical is still going to react to the presence of the blood. So then you have that reaction. And that reaction, ladies and gentlemen, tells you that someone is sitting in this seat. Because, as Detective Williams illustrated, it's where the blue star isn't. So where there is no blood. There's no blood where someone's would have been sitting. There's no blood where their legs would have been, and you can see on the V that's indicated on that. And there's no blood on the back of the seat. So ladies and gentlemen, what does that tell you? The killer was sitting there. And there's no blood because something was blocking it from getting onto that area of the car. So what do we know as well from this car? We know that there was also that this door was closed. How can that be said? Because, ladies and gentlemen, the blue star here shows that this door was shut because there was blood on this door handle. You have from this as well the headliner. So the headliner shows directionality. The headliner shows the way Anthony Williams' head was positioned when he was shot. That's one aspect of it. That DNA that was tested is all Anthony Williams, but we'll get to that. So the DNA, very strong support. 51.2 septillion times more likely to be that of Anthony Williams than any unrelated individual in the world. That was from Kurt Rhodes. If you recall, he was the expert on DNA. He told you and taught you how DNA is done, how everything works. So now putting those two things together, you can say, and the evidence shows, Anthony Williams, the way his head was in that Jeep, is that he is sitting in this front passenger seat, and as you can see, all the blood is dripping down the back of the seat. That tells you, ladies and gentlemen, and from the angle of entry when we get to the medical examiner's information, that his head was right here. So then we have one of the things that Detective Williams relied upon was the shirt of Cortland Henry. If you recall, there is a spot of blood on the front of the shirt. That blood, as Kurt Rhodes then told you, belongs to Anthony Williams. What does that tell you, ladies and gentlemen? That during the course of this shooting, Cortland Henry has his back against the driver's seat and is driving wearing this shirt when the shooting occurs. You know from that he is not the shooter. Why? Because if he was the shooter, the angle to get that wouldn't have the blood on the front of his shirt. It would have it coming across the driver's side and towards the side of the shirt, not the front. So on here you have the blowback coming there, and that's, again, 32.2 septillion times more likely to be the DNA of Anthony Williams. So then we have the back of the shirt. And so if you recall, the blood on the back of the shirt is right here. And that blood, Christopher Thomas, a single source profile. So what does that tell you, ladies and gentlemen? That tells you that Cortland Henry didn't fire the fatal shot.
And that's not a 2-minute discussion.
No, I agree. So you haven't discussed it with her?
No.
Got it. Okay.
Because Raven is not even here today because she's been flying back from Montana since yesterday morning.
So,
For Christopher Thomas. Here's why. That blood is coming from Mr. Thomas when he is shot. The blood's only moving like that, as you heard from Sergeant Williams, when there is a pulse, when there is pressure. Remember the garden hose analogy that he used and talked about? That's when you're getting the blood that's going to be coming out of the body. And on that, so from there, you know, Cortland Henry is ducked over and flinching away from Christopher Thomas. So he cannot get that shot on Christopher Thomas from where he is sitting in the driver's seat. Even if he was in the back seat. Let's argue that for a second. To get the blood there, he would have to have been completely turned facing backwards to Mr. Thomas and then turned and shot over his shoulder to get blood on the back of his shirt. That's not reasonable inside of a car. What is reasonable is that he's driving, the shot happens to Anthony Williams in the back of the head, blood gets on the front of his shirt. He flinches, comes down, shot happens to Christopher Thomas, blood gets on the back of his shirt. So that was the other aspect that we learned from Anthony Williams, because there was the entrance and the exit wound. So from there, ladies and gentlemen, you can tell, again, the side-to-side orientation of the head, because that front passenger window is blown out. That tells you that his head was not upright, but it was laying over to the side. Because if you recall, the entrance on Mr. Williams is back behind his left ear, and the exit is up here in his hair. If he was sitting up and awake and knew what was going on, you would expect to find a projectile in the headliner and the roof of that Jeep. But you don't. Instead, you know, based on his head angle, that it goes out the window, blows out the glass. For Christopher Thomas, he is in the rear. So what do you know about Christopher Thomas's wound? That it's coming in at almost 90 degrees on the left side of his face, and that there is stippling. You learned about stippling, the imprint of unburnt gunpowder into the skin of a living human being. Powder tattooing, it's also called. So on Christopher Thomas, you learned from Sergeant Williams, as well as from the medical examiners, that the firearm that inflicted that wound was approximately 3 inches to no more than 3 feet. Sergeant Williams said his estimation is no more than 12 inches away. And so why is that important? Let's go back and argue the Cortland Henry. If Cortland Henry was making these shots from the driver's seat, you would expect Anthony Williams to be covered in stippling, because they're that much closer and nothing would be blocking or impeding that shot. But if the shot is instead coming from the rear passenger side, you're not going to have that same stippling on Anthony Williams because the seat's in the way. Cortland Henry, there is nothing blocking it, so you have the stippling. So ladies and gentlemen, that's one of the things that you would notice, and the differences that show that why it could not have been Cortland Henry in the driver's seat with this weapon. We know it can the backseat passenger, it could have been, because there is stippling. If it was the backseat passenger was shot by the driver, you wouldn't see that pattern of stippling because they couldn't get close enough to make that pattern in that imprint. So then we have all the drive-by on the trajectory rods that we talked about briefly. But this one is important because this is talking about strike K. So why is strike K important, right? Strike K comes in and hits the front of the rear door. That tells you that that door was open when that drive-by was staged. Because as you heard from Sergeant Williams, if this was actually a drive-by, this is what you would have seen. Strikes coming in at different angles, at obtuse angles. There would be angles of entry that would show either a pattern of speeding up or slowing down. But instead, you have them coming in at 90 degrees. And that goes for the front, on the
34 counts total, all right? Let me go through them real quick.
and then you have strike K going across. And remember, this is, Chris Carter took this picture that shows you where strike K impacted this door. If this door had been closed, you would expect it to be going into the speaker. That's where you would expect it if it had been a closed door. That's not what happened. Also, if that had happened during a drive-by, whoever was sitting in that rear driver's side passenger seat would have had a projectile right through their knees. That was the path of that bullet. Talking about as well on the driver. If you recall, ladies and gentlemen, projectiles are found underneath the brake pedal. You don't see any injuries on Mr. Henry. He got out of that car too. So the shots from the back of the car, same angle of entry. They're not coming from the side. They're not coming in like there's any difference. So now, ladies and gentlemen, I have to talk about the medical examiner's information. I know it's difficult. So what I'm going to do is I'm going to put a picture up briefly, then I'm going to move to a blank slide to talk about it. So everyone, not trying to traumatize anyone, is part of the case and it's evidence, so I apologize. So as you've learned, Anthony Williams' autopsy was conducted by Dr. McDougall. Dr. McDougall, if you remember, had COVID. She came in and testified. So again, we have Anthony Williams. What did you learn during the course of Anthony Williams' autopsy? You learned that this is one of 3 times that Dr. McDougall could ever testify what was the fatal shot and which shots were post-mortem. And so I'm going to move on, and the next picture is going to show the fatal shot. Again, A is the entry wound, and E is the exit wound. And again, that shows the angle in which his head was positioned. And also it shows the lack of stippling, showing that that firearm was further away than that of from the wound that was inflicted on Christopher Thomas. So then I'm going to show you for comparison the difference with the post-mortem, where it's white, there's no hemorrhaging, there's no signs of life, body bleeding on these wounds. And these are the ones, if you recall, to his shoulder and to his torso. And so the one from his torso, which is B, came in through the side of the car and was into his body. And if you recall, the one that's site C came from one of the shots through the back of the car and into his shoulder. Moving on to Dr. Sodders with Christopher Thomas. As to Christopher Thomas, you learned about the stippling and the pattern that's on them. You learned the distance determination, and you learned that the wound through his head was the one that caused his death. And that was the one for which he was alive. You learned that when you're stippling, those are those tiny black implanted bits of gunpowder. So if you recall from George Bello, he drew the cone. You have a firearm, and as the parts from the firearm that are expelled, you have the projectile that goes forward, and then you have the cloud that gets increasingly bigger as it travels away from the muzzle of the gun. The example, if you take a handful of dust, sand, and a golf ball. You learn the golf ball is going to go the farthest because it has the most mass. It has the most weight to it. So the most energy can be transported to it. The golf ball is like your bullet. The sand is your unburnt powders of gunpowder. It's going to travel, not as far, but it has more mass, so more energy can be transferred to it than that of the dust. The dust falls out quickly. That's why we can say it's not 3 inches, but that's why they can say it's less than 3 feet from the medical examiner's perspective. So going to the wounds on his back. Again, no signs whatsoever of any blood, hemorrhaging, in any of those wounds. There are projectiles that intersect his lungs. You heard Dr. Soder testify that the lungs bleed profusely if a person is alive. So, ladies and gentlemen, from all of this, at this point, the state has established that there was someone in that rear seat. The someone who was in that rear seat is the person who committed this murder. And so now the question is who? So I'm going to show you now why the state has proven who was Jamel Dennis. So we have the studio video. This is going to go through and you can track the defendant wearing that lyrical lemonade sweater all the way out to the Jeep, where he gets in the spot the murderer sat in. It's important to notice, ladies and gentlemen, that phone. Always, always, always in his hand. He doesn't let go of it, still in his right hand as he's going to go get in that rear driver's side seat. Same with that satchel. Recall, ladies and gentlemen, that satchel and the one that you see Christopher Thomas wearing are never recovered. So they were taken out of the car by the defendant. So let's talk about T-Mobile records and the phones and why this is important. Okay? So the question is, are the phones themselves, do they know where they are? And then does the network know where the phone is? So this, ladies and gentlemen, is one of the exhibits that was put in, and this is the phone of Mr. Devens at 3:18 a.m. If you will notice that there is right here a camera icon, and that is located at 805 Northeast 4th Avenue, because that's the camera from the studio that you just watched. And the blue pin is where the network thinks the phone is. Is it perfectly precise? No. But is it accurate? Yes, within a football field, right? We learned that less than 78 meters is the range on those bands for the timing advance. But this isn't the timing advance. This is where the network thinks the phone is. Ladies and gentlemen, the phones work. You know the phones work because in your daily life, when you need to go anywhere, you go into a mapping app and you put an address in. You don't have to know where you are to get somewhere because the phone knows where you are. These are things that you use on a daily basis. It's common sense. The phones work because you've used them. We've relied on them for years to show exactly how to get someplace. Look, in a populated area like this where there's multi-story buildings, okay, maybe it's a little bit more difficult to say precisely where a phone is. You can order a pizza by sending a drop-in. The phones work, ladies and gentlemen. We rely on them in our everyday life. So let's go and talk about the T-Mobile and the Sprint records. And so, ladies and gentlemen, what I'm putting up here is what I believe the evidence reflects. This doesn't go back with you. You don't get to take a copy of this into the back, but this is all things that are in evidence. This is a summary of them. So these are all the phone numbers that were in use in October of 2018. I am not suggesting they are still being used by these individuals. So at this point, the state has established, based on the business records from Sprint, Christopher Thomas, 772-713-2341. Anthony Williams, 954-248-9081. Mr. Demons, 772-713-9807. Cortland Henry, 561-720-3210. Jamie King, the mother of Mr. Demons, 772-501-6942. Jameson Francois, track, the manager, 954-376-9158. Frederick Gibbons, the Louisiana-based rapper who lived the next community over, 225-529-5054. And then Octavius Withers, one of the other individuals in the red Mitsubishi. 954-371-7895. So from these phone numbers and those records are where we're getting the information as to where the people work. So ladies and gentlemen, I encourage you to go through and look at those records. Look at who the subscriber is. Jamie King was paying for the phone of Anthony Williams and Jamel Demons. Doesn't mean she was using it. In fact, she's listed under the billing information, and that's her number. So you have that, and that's the 772-713-9807. And you can tell the date the service began, November 30th, 2017. Ladies and gentlemen, it's important to look at these things and things that start before the murder. Because when people are creating email accounts, when they're setting up social media, when they're buying phones years before, they're not trying to hide anything at that point. So I submit to you that those are things that are reliable because there's no motive at that point to lie. So we have, again, like I said, she's under the billing for Miss King. So we have Cortland Henry. And so if you recall, Detective Moretti talked to you about Cortland Henry. Because it was a question, oh, it's so weird he doesn't have a phone. Well, you learned that the phone that he had was a pay-as-you-go phone. So it was a minute phone. And you also learned that every single phone call that came into that phone on October 26th of 2018 went straight to voicemail. What's a reasonable inference, ladies and gentlemen? The phone wasn't on. You didn't have minutes, or it was broken. That's what those records show. They don't show Mr. Henry making a ton of phone calls and passing the phone off to someone else. No, they show a phone that was not operating. So looking at the CDRs, so this is from Mr. Demons, the 9807 phone number. What I've done, 840-34 at the top, that's going to be the time that reflects on the records as you can look at them. That's the UTC. So as you've learned, that the difference between UTC, or Greenwich Mean Time, in Florida, on October 26th of 2018 is 4 hours. So that is 4 hours ahead. So to get from UTC time to Florida, you subtract 4. Until November 4th of 2018, daylight savings time, right? Fall back. Then you subtract 5 hours. But for the time in question, October 26, 2018, you subtract 4. That's the same whether you're looking at the CDRs, whether you're looking at the Facebook or Instagram records. So that way you can help and cross-reference to see what's going on with an individual phone and where that phone is when these messages are being sent and when the social media is being accessed. So if you recall, ladies and gentlemen, we learned that the 805-637-7249, if you see an incoming phone call and then that immediately outgoing to that number, it says it goes to voicemail. So right there, you have at 5:03 a.m., Jamie King calling the phone of Jamel Demons, her son, and being sent straight to voicemail. Then you have an incoming phone call from Frederick Gibbons, Frito Bank, that lasts 491 seconds. You then have another incoming call, only 11 seconds, and then Jamie King again sent to voicemail. So let's talk about the surveillance footage. And I know, I warned you ahead of time, there are some parts of this that are incredibly boring, utterly tedious. but they're important. And sometimes it's the smallest details that show that, look, this is what it says it is. So you have here 3:35 a.m., 36 seconds. And as you recall, this is the camera that sits on 595 on the entrance and exit to the express lanes. You learned from Detective Moretti that the express lanes toll camera all the way out past 136th Street. So ladies and gentlemen, from here, you know from the studio at 3:19 a.m., we're now 3:35, 16 minutes later. We have two cars, and you can go and pull this up. And if you need any assistance with doing that, we'll be happy to bring it back up in court and show it to you. You have two cars, and you can watch. So the top lanes are looking east towards Fort Lauderdale. So when you watch these videos, you'll see two cars that come here on the eastbound, and then they're gonna pop up down here on the westbound camera, and they're heading west. And ladies and gentlemen, I submit to you, if you watch these two cars, one red and one gray, you will see them come up here and go to the left to get onto the ramp over to I-75 South. You can see here the lights going to the Sawgrass Expressway up to the Panther Arena. But if you watch those two cars at 3:35, that's what you will see. They go over to the left, head south towards Miramar Parkway. And so what you've learned, again, we have the camera icon, and then we have where the phone suggests the network it says it is. Blue dot right there at the bottom. Again, meters, not miles. We then have McDonald's, 3:47:56 and 3:46:57. So 1 second apart on those two cameras. And there, remember, we saw the red car go first, then the gray Jeep on 595. You're looking here, red car, gray car. So on surveillance footage, when a business, a private residence puts up surveillance cameras, they're not there for the benefit of law enforcement. They're there for the benefit of that business. So they're not required to capture the street that goes by. They're not required by any law to maintain those videos for any longer than they feel is necessary. They're there to make sure that if someone's coming through and burglarizing their business, they capture that information. The fact that they also happen to catch the cars going by is dumb luck. But this is not just dumb luck, because this is one of the parts of the investigation that Detective Moretti talked to you about. That they went out and went to multiple businesses. And look, these aren't officers that have been there 2 weeks on the job. Detective Moretti talked about, yeah, I've done tons of investigations at Walmart. I know their video retention policies. This is their jurisdiction that they are intimately familiar with as to where these cameras are and what they show. If you have a camera that's pointing in the completely wrong direction, you don't need to waste time to go in and look at something that's not going to show you anything. Or if you know the data retention period has already passed, because most are 7 days or less, you don't need to go back and do that again. So if you look at, again, we have the McDonald's. This is where the network thinks the phone is at 3:47. Meters, not miles. But this is showing you that those records are accurate. They're not explicitly precise, but they are accurate. Going to 3:53 a.m. This is the Montessori Academy. So ladies and gentlemen, you can see there's the Montessori Academy, and there is traffic. There is a car that is consistent with that gray Jeep going by at 353, at 406, and again before 420. You can watch that and look at that. It's not like there's no cars, there's nothing out there. There is things that corroborate that cell phone evidence. We have Sunset Lakes. That shows, and again, 3:50 a.m. So ladies and gentlemen, you learned a lot about the geography of Miramar and Fort Lauderdale and the distances between. You learned from 805 Northeast 4th Avenue in Fort Lauderdale, Florida, to Sunset Lakes, the 40th Street Visitors Entrance. You're looking about 31 miles. Detective Moretti talked to you about driving that route, and rather than spend
All right, can y'all hear me? Y'all give me some feedback in the chat if you can hear me. And tell me if my voice is really loud or what. Cool. Am I real loud? I got like a kind of a new setup and I really don't know what it sounds like on y'all's end. Okay, cool. So we have, this is YNW Melly, Jamel Damon. Sounds lower than normal. Slim Life, there's no rundown. There's no rundown to give right now. This is a rapper. He's in trial. Well, I guess this is the rundown. Rapper, he was on trial for killing two of his friends. 2023, he went to trial and had a hung jury. He's going to be going back to trial this year, and this is a hearing today for different
Let me
motions.
go back on the record. This is on the FT docket on the top of page 4. States versus Jamel Dennis. I've got Ms. Buckaloo, Ms. Collins, Mr. Griffith, written for the state. I've got
And this is the audio we have.
for Mr. Dennis, who likewise is present. Mr. Aronson, you're telling me we're going forward without Ms. Liberty, without Mr. Benjamin, and without Mr. President. Is that correct? Yes. So, in preparation for the 2 days of all pending motions, I was going to put on the record, I know that the defense wants me to take one of these out of order. I think they're probably correct about that. But let me just put on the record real quick, everything that I've read in preparation for the all pending motions that I gave you all day today and all day tomorrow for. I endeavored to try to read everything in the electronic file, all filings and any authority cited therein that took place since this trial was declared, this previous trial, which was July 22nd, 2023. So these are all the pleadings that I read that were filed by the defense. I did read also all the orders that Judge Murphy entered, but I do realize some of these may be due, but in the abundance of caution, so I would be prepared. I nevertheless did read all of them. As we go through them, I'm sure you all will let me know if it's something that I need to resolve or it's something that's already been resolved. The defense, and I'll do these in chronological. I read the defense motion to compel Brady material that was electronically filed August 23rd, 2023. I read the defense motion to compel discovery that was electronically filed August 31st, 2023. I read the defense motion for discovery of prosecutorial investigations and prospective jurors electronically filed September 6, 2023. Defense motion for disclosure of penalty phase evidence electronically filed September 13th, 2023. The defense's motion in limine regarding phone, social media, and business records electronically filed September 21st, 2023. Defendant Jamel Dennis' motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health phenomena electronically filed October 4th, 2023. Defense motion to exclude testimony of defendant's alleged gang affiliation electronically filed October 4th, 2023. Defendant Jamel Dennis' response to state's motion to quash subpoenas and/or for protective order and for an order to compel witnesses to be deposed and to attend hearings electronically filed October 4th, 2023. Defendant Janelle Demon's motion to compel discovery, electronically filed October 4th, 2023. Defendant Janelle Demon's motion limiting to exclude certain testimony of Detective Mark Ray along with cell hawk, call, data, record, mapping, and Google Maps, electronically filed October 5th, 2023. Defendant Janelle Demon's motion limiting to exclude certain testimony of Detective Mark Moretti regarding Apple Health Phenomena, electronically filed October 5th, 2023. Motion to exclude testimony of expert witness and memorandum of law, electronically filed October 6, 2023. Response to state's motion to quash a memorandum of law, electronically filed October 9, 2023. Memorandum Ray, ASA, Christine Bradley testified, electronically filed October 9, 2023. Defendant's second motion for redeposition of Detective Mark Moretti, electronically filed October 29, 2023. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights.
Judge, that can be struck because we filed the third one and that incorporated the second. And already have a ruling on the third one.
Okay, well, hold on. Let me get all of them,
All right.
and then we'll go one at a time. That's why I gave you 2 days. This one is defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. That one was filed November 1st, 2023. Defendant Janelle Demon's motion to exclude, electronically filed November 2nd, 2023. Defendant Janelle Demon's motion to strike the state of Florida supplemental discovery, electronically filed December 14th, 2023. Defendant Janelle Demon's reply to the state of Florida's response to defendant's motion to strike the state of Florida supplemental discovery list, electronically filed December 17th, 2023. Objection to business record certification and or motion in limine, electronically filed December 18th, 2023. Defendant's third motion to compel forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams, electronically filed April 15th, 2022. Defendant's request for status hearing, electronically filed April 15th, 2024. Defendant's motion to set aside stay and or modify stay to allow discovery to proceed, electronically filed April 25th, 2024. Motion to compel discovery, electronically filed May 13th, 2024. Defendant Janelle Demon's motion in limine number 2 to exclude irrelevant and immaterial YouTube videos of 1090J, electronically filed May 14th, 2024. Defendant's motion to strike the state of Florida's motion for rehearing dated May 14th, 2024. That is electronically filed May 14th. And then a defense motion for hearing to determine potential conflict, electronically filed December 27th, 2020. From the state attorney's office, I read the following. State's motion to refer to potential and seated jurors by number instead of name, electronically filed October 6, 2023. State's motion to allow former testimony of state witness, filed October 6, 2023. State's motion to strike State Attorney Harold Pryor, Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Kilram from Defendant Demon's supplemental witness list for trial, filed on September 29, 2023. This pleading was electronically filed October 10, 2023. State's motion to strike Assistant State Attorney Christine Bradley from Defendant Demon's supplemental witness list for trial, filed on September 29, 2023. That's electronically filed October 10, 2023. State's motion for admissibility of consciousness of guilt evidence and request for ruling prior to jury being sworn, filed October 20th, 2023. State's motion to withdraw State's motion to strike ASA Christine Bradley from Defendant Demon's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed on October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demon's supplemental witness list for trial, filed on September 29th, 2022. That is electronically filed October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demon's supplemental witness list for trial, filed on September 23rd, 2023. This is not a duplicate, this is an additional document also filed on October 25th, 2023. States Board Memorandum of Law, electronically filed October 30th, 2023. State's response to defendant's motion to redepose Detective Mark Moretti, electronically filed October 30th, 2023. State's motion to strike all jurors for cause with significant knowledge of the previous trial, electronically filed October 30th, 2023. State's motion for protective order and quash subpoena, electronically filed October 31st, 2023. State's motion limiting to prohibit defendant from improperly pre-trialing this cause or making misstatements of law during board action, electronically filed November 1st, 2023. State's response to defendant Jamel Demon's motion to exclude, electronically filed November 6th, 2023. State's response to defendant's motion eliminating the phone, social media, and business records, electronically filed November 6, 2023. State's response to defendant's motion to exclude testimony of defendant's alleged gang affiliations, electronically filed November 6, 2023. State's omnibus memorandum of law in opposition to defendant's motion to suppress evidence, electronically filed November 6, 2023. State's memorandum of law raised striking jury panel due to defense misstatement of the law, electronically filed November the 8th, 2023. State's motion to strike the defendant's second motion to dismiss for government prosecutorial misconduct in violation of the defendant's due process rights, electronically filed November 28, 2023. State's motion to strike the defendant's unilateral setting of depositions and the state's proposed deposition and motion schedule, electronically filed December 16, 2023. State's response to defendant's motion to strike the state of Florida's supplemental discovery, electronically filed December 16, 2023. State's motion limiting to exclude testimony of Michelle Boutros and Christine Brett, electronically filed December 17, 2023. State's motion to strike the defendant's sworn motion to dismiss, electronically filed January 12, 2024. State's response to defendant's objection to business record certification and or motion in law, electronically filed January 23, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 15, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 17, 2024. State's response to defendant's motion titled Third Motion to Compel Forensic Images of the Cell Phones, electronically filed May 20th, 2024. I did also today do the state's motion to strike defendant's notice of hearing, electronically filed January 2nd, 2025, as well as the state's response to defendant's motion to compel discovery filed on May 13th, 2024, electronically filed January 2nd, 2025. As far as previous orders that Judge Murphy entered, I read all of the following. Order denying defendant's motion for redeposition of Detective Mark Moretti, entered August 7th, 2023. Order on motion to remove electronic monitor, entered August 25th, 2023. Order denying defendant's motion to set bond, entered September 22nd, 2023. Order denying defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in and for Broward County, Florida, entered October 12th, 2023. Order granting defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley, entered October 12th, 2023. Order granting State Attorney's motion to quash subpoenas and or for protective orders, entered October 12th, 2023. Order denying defendant's motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights, entered October 20th, 2023. Order on state's motion for inquiry of all pre-qualified jurors and motion for relief, entered October 26, 2023. Order granting in part and denying in part defendant's second motion for redeposition of Detective Mark Moretti, entered November 7, 2023. Order denying defendant's motion to declare section 921.141 subsection 6 subsection N of the Florida statutes unconstitutional. Entered November 14th, 2023. Order on deposition of state witnesses. Entered on November 15th, 2023. Order granting the state's renewed motion to reset the trial commencement date. Entered November 15th, 2023. Order denying defendant's motion in limine re agreement between Devens and Williams as to sharing of any money. Entered November 17th, 2023. Order re second deposition of Detective Danny Polo. Entered November 21st, 2023. Omnibus order on defendant's motion to suppress numbered 1 through 13. Entered December the 20th, 2023. Order on the state's motion for rehearing / reconsideration. Entered January 11th, 2024. Order on defendant's motion to dismiss for violation of due process and double jeopardy and/or motion to recuse entire state attorney's office of the 17th Judicial Circuit. Entered January 19th, 2024. Order on state's motion for clarification. Entered January 24th, 2024. Order denying the state's motion for reconsideration. Entered January 25th, 2024. Order granting defendant's motion in limine re promotional video. Entered January 25th, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed. Entered May 2nd, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed. That's a duplicate. Order denying the state's motion for rehearing and reconsideration of the court's order modifying the stay to allow discovery to proceed, issued on May 2nd, 2024. That's issued on July 16th, 2024, non pro tunc to May 16th, 2024. So, that's everything that I looked at, as well as any authority cited therein, statutes, case law, or otherwise. You don't have to repeat yourself, but you certainly can if you would like. I have the balance of all day today. I take a lunch break between 12:30 and 1:45. I can likewise give you the entire day tomorrow. I won't limit either side to present whatever evidence, witnesses, or testimony they would like to present. Defense, I'm going to start with you, and I also did read Rutledge versus State, which is 157 3rd 830, regarding the defense motion for hearing to determine potential conflict. So, whenever you're ready, you may proceed.
Thank you, Your Honor. Rutledge and other cases, federal cases, because state law really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devens to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demings, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not, that's been waived up until that time. I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Deming's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Demings, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demings' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demings' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Miss Liberty is in fact facing charges for them. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, at a prejudice to Mr. Demons would be monumental that at this stage you'd have to get a whole new defense team. So we need these questions answered. It's not just as simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state, wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demons, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demons in person for the last, I think before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demons on the other side of the glass partition by phone. Have they been tapped? Have they been listened into? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Demons and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with a case I cited to the court, I think all members of our defense team need to call up the Florida bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Demons' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Demons has a lot of thinking to do. Hopefully, the court will give us a hearing and some of these questions are answered, and then he can make a logical and informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge said, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want to answer? Because I didn't find any authority with that. I don't even know how I would do that. Well, do you have any authority? I understand you're saying, that's the judge, this is what we'd like. I read what Rutledge says. That's what I'm doing right now. But you want to know about investigations. You want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires me and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. What do you I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? And the answer is yes. So the only other question that Rutledge requires is that Mr. Demons has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your clients, or your client can make an informed decision.
Well, right. I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. there's a whole laundry list that deal with not only
That's
conflict.
what I'm at. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this board that you should do that. And there's certainly nothing that says you can't do
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
that. Well,
criminal procedure tells me to do. I don't make up things on my own.
then I asked the court, let's go one step at a time. Right now, Mr. Dennis now has been informed that Ms. Liberty is under investigation. And let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demons needs to know these before, quite candidly, he can make that choice. He can say right now that he wants Miss Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Miss Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today?
I don't think we can.
When would you like me to reset them?
I do not know how long it will take. Miss Liberty is not in Caveat right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight, including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30, but I do think it takes some time for us to talk to Mr. Demons. She certainly needs to talk to Mr. Demons. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, you can't. And we need to develop, if I may.
Yes, sir.
We need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the taint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabanis. And I sent them a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi, Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called taint team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
Has
that's all I
anyone said
have.
anything that this has anything to do with Mr. Demons?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Demons?
It doesn't.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Demons make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. We can't give anything over until it's
Well,
officially completed.
With all due respect, Ms. Buckfield, this is the high due process part of the state seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right.
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll speak with my office and you can have a week to figure this out.
Judge, they've had since December of '23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery for her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demons has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can have them, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant from being over.
I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand that. And then I'm asking for at least a day or two. At
You can
minimum.
decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't under the Florida bar rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Demons. And state, you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant.
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so. But maybe it's something so de minimis that Mr. Demons is going to say, that's fine. If there's any conflict, I'll waive it, and, let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So how about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30?
That's fine, Judge.
And it can't, again, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Just one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we will get a ruling. The problem is the stay that was issued by your previous judge. We cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions.
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there's a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, can I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, your example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just.
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of a waste of time to do the motion.
Well, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and me hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
Then I'll be candid, I do not think we were hearing the Instagram matter whatsoever. So I'm not looking at that motion.
Okay, so why don't we do it this way, all right? He's gonna remain on the docket tomorrow. I have a few other matters on both FX and MT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me if you had a chance to talk to your client, because if he's gonna waive any potential conflict, I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're gonna tell me what you wanna do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in honesty. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for somebody's.
you're gonna go to trial in September. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's gonna go to trial in September. So I'm gonna do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're gonna do. So,
Assuming we're still on the case. And that's a big assumption at this moment.
And just, we're still asking for proper notice of what we're actually
I'll take the blame for that. All pending motions. That's why I put that down for the anymore. All pending motions. They're asking for I believe they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things that.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title. She's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX NFT for today?
Yeah.
Okay. So the FX NFT are both otherwise being recessed until tomorrow, which is.
Excuse me.
Yeah, yes, sir.
I've been told that Mr. Devens has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent one.
Tomorrow is Tuesday, January the 7th. FX NFT will be recessed until then at 8:45 a.m. That would be all be good for the rest of the morning. All right, Mr. Court Reporter. That is it.
Yes. You say right now? Oh, okay, 2 minutes.
Here.
No, the jail.
The jail.
Yeah. Thank you. Thank you. May we be excused?
Yeah, whatever you want. Have a good morning. Use your time wisely.
Yes, sir.
All right, y'all. Looks like that will be all for now. Thank y'all for popping on. Yeah, we'll be back tomorrow. Might go live a little bit later, y'all. Y'all know I've been doing the grand grinding. I had to get a new camera, which I did, so that y'all can see me better. So let's see if maybe we go live a little later. If not, I'll see y'all back mañana morning. Y'all hit the like button. Appreciate y'all. Have a good rest of y'all day. Bye-bye.